And on to debate number 2. An order passed by the Chhattisgarh High Court in what was initially termed as a rape case has sparked major outrage. Hearing the plea on Monday of a case that pertains back to 21st of May 2004, the High Court referred to medical reports of the survivor, following which the court has reduced the sentence of the accused from 7 years to 3.5 years, citing that hymen of survivor was intact. The court has also concluded that while there was evidence of sexual assault and intent, since there's no conclusive proof of penetration, this can't be considered a case of rape, but has to be restricted to a case of attempt to rape. Here are some of the observations of the single judge bench of Justice Narendra Kumar Vyas. The High Court has said that indecent assault often magnified to attempted rape. Evidence to gratify passion of accused necessary. Ejaculation without penetration is not actual rape. Penetration is sine qua non for the offense of rape. Forcing victim into room is preparation of offense. Appellant guilty of attempting to commit rape. Remember, this isn't the first time that a High Court order on such sensitive cases has sparked outrage. In March 2025, similar observations from the Allahabad High Court had also drawn widespread condemnation. In that case, the High Court believed the act did not cross into the threshold of attempted rape, but Supreme Court eventually overturned that order. Here's what we're talking about. What the High Court order specifically said in March 2025 is that two accused grabbed the breast of victim. One of them broke the string of her pajama. He tried to drag her beneath the culvert, and then accused persons fled from the spot. Not sufficient to hold the case of Section 376 of the IPC. The latest order from Chhattisgarh High Court has sparked a major debate, with experts from the legal fraternity voicing out their concern over the order passed by the High Court.
The Chhattisgarh High Court's observation today to the aspect that an offence of rape could not be made for the reason that there is no sufficient penetration is true on one aspect, for the reason that the hymen was found intact in the medical examination, and their statement was also to the aspect that there was no penetration. So, in order to constitute an offence of rape, as per the definition of the Indian Penal Code, penetration of the male organ or any part of the organ of the body is into the woman's organ is much more important. So, since the vital ingredient of the offence is missing, it can only be stated as an attempt of rape.
Courts may interpret the law as a written, but let's be very honest. If the law allows such conclusion, then the law itself is failing our women. When judgments rely on narrow definitions, they send a dangerous and irresponsible message to the society that some form of sexual violence are somehow less. That thinking doesn't deliver justice. It protects perpetrators and the criminals, and on the contrary, they discourage the survivors from ever speaking up against such criminals. Was consent violated? If yes, then the law must stand firmly with the survivor, not hide behind the technical language.
The order, the judgment passed by the Chhattisgarh High Court is absolutely unconstitutional. A penis ejaculated over the vagina is not rape. What is it then? Is it not attempt to rape? And is attempt to rape not as heinous as rape itself? How can judges in High Court interpret something like this? Sexual assault on women will continue because perpetrators, rapists, murderers know that they have judges who will let them off.
You're watching the News Hour at 10, debate number 2 on Times Now, Super Prime Time.
For more of this, let's go right across to our guest. Joining us is Pratibha Prahlad, renowned artist and socio-political commentator. We also have Deepika Narayan Bhardwaj, activist, joining us. Joining us also is Swapnil Kothari, advocate. Joining us as well is Jay Dehadra, advocate on record of the Supreme Court. Barkat Rian, activist, also joins us on the show. Let me begin with you first and foremost. Jay Dehadra, now we all know how the criminal amendments when it comes to heinous crimes such as rape have been amended in this country. Yet you have such shocking observations coming in from the High Court. And why this is so important is this is not an isolated case. You've seen what has been stated in Mumbai, what has been stated in Allahabad, and now yet again you have such a bizarre comment coming in from a High Court which shows utter lack of sensitivity to the kind of trauma that a victim in such a case would have gone through. What's going on?
Madhav, good evening. Look, right at the outset, please let me make this absolutely clear for your viewers, that a judge goes by the evidence and evidence alone.
Yeah, exactly.
And in this case,
Exactly.
let me tell you, I've read the judgment. This judgment is 100% correct. He goes by the fact that the evidence of the victim, and my heart goes out to her, and please, for a moment, please don't assume that I'm trying to minimize her pain and suffering, and it's awful what she has gone through. But please remember that the offense happened in the year 2004, and criminal law operates prospectively, not retrospectively. The amendment came in 2013. So insofar as the evidence and the record exists, Madhav, on the record, the victim herself has stated that no penetration took place at all. This statement was further corroborated by the doctor, the medical examiner who studied the child after the incident. And this was also confirmed and corroborated by the doctor. So I would like to frame this a little differently. For a change, let us please congratulate and thank our judges for upholding the rule of law, despite the fact that they might get a lot of abuse in social media and in the press. So insofar as I'm concerned, as a criminal lawyer, this judgment is absolutely perfect.
Let me bring in the counter view. Pratibha Prahlad, do you agree with that? In 2013, the criminal laws were changed. This is a case from 2004. Yet our legal system is so slow that in 2026, we are still talking about the old law and cases from 2004. It's a very sad reflection of us as a society and how our criminal judicial system works.
So, Madhav, my main point is that sexual assault and rape should not be seen just as physical crimes. Okay, they are a violation to the autonomy of a woman's body, her psychological state, her trauma, her, and the dignity and the life she's going to lead, even if she survives this, this assault. So many women who are survivors have said that there's a lifelong PTSD that they kind of go through. There's a, fear of social stigma, there's fear of educational kind of, hindrance or societal acceptance. There are lots and lots of problems for women who have gone through or who become victims of sexual assault and rape. So this penetration theory, I'm totally against. And when the law came in 2013, Madhav, all of us applauded the law because we said no longer does a woman have to get raped twice. I mean, in the sense that once raped by the man and second raped by the law, the justice system, when you have to say that they had the four-finger theory or the whatever thing, penetration basically. So sexual assault and penetration or whatever, I mean, cases such as this, violations to bodily autonomy, violations, the mental trauma, stress should not be just seen as penetration or otherwise, because if this judgment is upheld, a lot of men get away with, a lot of horrible things that they can commit to a woman and then say that, oh, there was no, penetration. So I'm totally against this judgment. And I do agree, I mean, I do accept, what the lawyer who spoke before me said. He said that, you cannot apply the law retrospectively, and I accept that. But even then, justice should be in spirit, not in law. And a woman's lifelong violation of her entire body, her physiological state, her psychological state, the trauma she goes through, the whatever alters in her body, her mind, her spirit, should be taken into consideration. And justice has to be sensitive to that. And a perpetrator has to be, accordingly punished.
Yeah, let me bring in Barkhat Rehan on that note. Barkhat Rehan, law has to be applied not just in the letter, but the spirit of it. The spirit and the letter both changed since 2013. But yet, what is happening in this particular case is that we are still looking at it as an attempt to commit rape. And therefore, somewhere or the other, there has to be a sensitivity to the larger reason that the entire legal system has changed. Because otherwise, there is no end to this.
See, I'm not supporting any crime over here. I'm just supporting the correct application of law. Court did not release the accused, mind you. They did not release him. They have punished him. It only changed as the guy who spoke first, he said that the legal section based are always on the evidences. So if penetration is not not proven, legally it cannot be called a rape. Law is very clear. And definitions are very clear. Emotions cannot replace here anything. See, in the courtrooms, emotions don't work. While talking, we can talk emotionally, but medical proofs matter. Many other things matter in this, and then the proof matters. Judges cannot assume anything, or because again, wrong labeling of a man destroys his life also. And rapist is not just a word; it is a permanent social punishment. So I agree with him, what he said, that he has read the judgment and it is 100%.
No, but I have a problem with this because, with this contention, let me bring in Deepika Narayan Bharadwaj. Deepika Narayan Bharadwaj, during the course of the trial, I'm reading out from a report, the victim inter alia stated that the appellant penetrated his private part in the vagina. However, she further stated the appellant kept his part above the vagina for about 10 minutes but didn't penetrate. Now, the point is, why is the court going with one statement and not another statement of the victim? The victim might have changed statements, but who's the benefit of the doubt being given to and for what?
Well, Madhav, we have to understand that criminal law, criminal jurisprudence is structured a certain way. If there is an attempt to a certain crime, you cannot convict the person for actual commission of crime. So, if somebody has done attempt to murder, you can't convict the person for murder. Sexual crimes are very, very serious crimes, Madhav, but at the end of the day, judges have to go by law. This is a case from 2004. It is an absolute travesty of justice that in 2026, the appeal has been decided,
Very right.
So basically, nobody gets justice here. The person who actually perpetrated a very, very serious crime, he has been out on bail and, sort of enjoying his life for the last 22 years. Nothing has happened to him. And now he is given just a sentence of 3.5 years, which is according to the punishment that was there at that time. The larger question here, Madhav, is there has to be swift justice. I don't even know what this justice or this conviction actually means for the victim here. She was assaulted in 2004.
Absolutely, 22 years later.
Madhav, I recently met an acid attack victim whose perpetrator was released after 7 years. And I asked her, you should file an appeal. And you know what she said? She said, ma'am, I want to live my life now. I cannot spend my whole life trying to get justice and trying to punish this person. So it is the lethargy of the system, Madhav, and not just the comments of the judges. It is the lethargy of our courts to give swift justice to victims, which actually feels like justice. Pratibha said it very rightly. Justice has to be done in letter and spirit. But at the same time, let us understand the judges cannot go beyond evidences in law and in its perspective of whatever the available, statement.
No, there are so many bizarre judgments. And I want to, before I bring in Swapnil, in fact, let me bring in Swapnil on this. Swapnil, just yesterday, the Supreme Court had to undo after close to a year what the Allahabad High Court had specifically said, that pulling pajama string, attempt to grabbing of breast, etc., is not amount to the offense of rape. Earlier, we have seen what has happened in the Mumbai High Court, where they said skin-to-skin contact, so on and so forth. Now, the thing that is absolutely mind-boggling is that these are high courts of the country. They have a mandate to ensure that the constitution is upheld. If this is the quality of judgments coming in from the constitutional courts of the country, then God only knows what is happening in other parts and in other courts of the country.
Well, Madhav, this is what we call the polyvocality of law. That means you have different judges saying the same thing, or rather different thing on the same issue. Now, what is happening here is that when high courts pronounce judgments like this, you view it in the perspective of 2004, 2013 amendments, and you say that, okay, 7 years judgment has been halved to 3.5. You've gone by the letter of the law says this. But, just for 10 minutes, if your genitalia was above the vagina, so that means it's not rape because there is no penetration. Now, the fact is that this would hold good if you had decided this judgment in 2006 or even an appeal in, say, 2010, assuming 6 years were given or 2 years were given for the initial judgment and then 6 years or the remaining 4 years in appeal. But the fact is that when you do this after 22 years, what you are doing is that this will now be a precedent. Now, even if it's a precedent, depending upon the 2004 law, it will still be argued by people or by defense lawyers to say that, look, this judgment was there and this was a high court judgment and which overturned the sessions court judgment. So what happens is that when you do these kind of precedents, Madhav, this is the problem that you face. So my point is that, yes, when you go by the letter of the law, when you go in the interpretation of the section, you're not there to legislate, you're not there to make the law. But the point is that when you do this after 22 years, This is a factum of a fact that cannot be ignored. If the law was swift, I completely agree with the judgment. I may say on a given day that, well, in as much as I sympathize with the victim, but the fact is that the woman has been raped, not only in 2004, but...
Okay, many hands going up. Many hands going up. I want Jay to come in on this. Jay, does this set a wrong precedent when it comes to the law, even if it is as per the old architecture? Will it apply to those cases which are decided under the new law as well?
With great respect, I disagree with the very eloquent gentleman who spoke before me. He's very experienced, and I largely agree with him on what he says. But it is not like that. If the judgment that is coming out now by the Chhattisgarh High Court has decided something pre-2013, then certainly for offences that have happened prior to 13, Madhav, prior to the amendment, then this will hold good. But in any case, I want to point something out. There's something you mentioned very rightly when you said that, there were differing statements, Madhav, that the victim had given. You're very right in pointing that out. It's in the judgment. But may I also kindly bring your attention to the report of the doctor who also goes on to corroborate the fact that the hymen of the victim was also intact. So you have, yes, the statement of the prosecutrix, which has to be given a lot of importance, as Pratibha Ji also pointed out earlier. Deepika very eloquently explained what the law is, so I won't repeat that. But insofar as the application of law is concerned, it has to be objective. It cannot be a subjective application of law in terms of what perhaps public outrage wants it to be. So if you ask me, the earlier punishment, Madhav, was 7 years. It's been reduced to 3 years and 6 months, as Deepika pointed out rightly, because it's an attempt to plus the offence sentence. So that means 511 plus 375, which is rape. So honestly, if you ask me, I think the judgment is absolutely perfect. There is no reason for outrage. In fact, let me pitch it differently. I want us to, to compliment such judges who have the courage to come out with, to follow the law, the letter of the law, because there is always public outrage, Madhav, when such judgments come out. It's not palatable even to me. Personally, if you ask me, even this sort of an offense, a person should be strung upside down and hanged to death. To me, and this was a minor who was assaulted. But unfortunately, that is not the law. I am not a legislator and I cannot amend the law. So the poor judge has to go by whatever is the letter of the law in the book, in the statute book.
So Swapnil wants to respond to you on that. Swapnil.
Madhav, my only short point is the time taken for the appeal. 22 years. Now, that is my only short point. As I said, that when I go by the letter of the law, if 2004 this incident happened, 2006 he would have been convicted for 7 years, 2010 in appeal. Oh, sorry, no, I don't agree. This was not penetration. It needs to go to 3.5 years. That's absolutely fine by me. Because the point is that, yes, you are serving your sentence. The justice has been meted out swiftly. But for 22 years, the judge has the ability to give a reasoning. He may even go by the length of the time, and the judges, the High Court has got its full powers to do justice, just as the Supreme Court has to do justice, depending upon the facts and circumstances of the case and the country that we are living in and the climes and the times that we are living in. I am not a public person who will go by public outrage or anything. In fact, I would even commend the judge for a certain sense of, bravery on that, or, a certain sense of severity, saying that, I'm going to go by the law. But at the same time, I would appreciate if there was some sort of a sensitivity to the fact that this quantum has taken place. And yes, you have conflicting statements from the woman. The benefit of the doubt has to go to the accused. There is no question. That is the criminal jurisprudence. But I believe, as you rightly pointed out, that just one sentence cannot suffice. I'm sure there were other incriminating, evidences to the fact that the man was there on top of her for 10 minutes. I don't know what he was doing, but the fact is that she was gagged in the mouth. She was stripped. I think that
because itself... the only thing that I will say is, I'm not going to get into the specifics of this, but the fact that there was even found in the undergarments of the victim, there's several aspects of this which are entirely debatable. The point I'm just making, Pratibha Prahlad, you have several lawyers who say that the judges should be commended. But the point is, this is 2026. How long are we going to see the sort of judgments that one was seeing pre-Nirbhaya era? India has moved on, the citizens have moved on, but our legal judicial system remains the same.
This is an extremely, extremely sensitive topic, and many of us have, many in this country have lobbied to have the laws changed. So that two-finger medical test which proved penetration we had to change that. So this is not about medical examination. It's not just physical abuse. I'm going to reiterate again that this is psychological abuse. It's lifelong trauma. It is societal stigma. It is so many things. It's post-traumatic stress disorder and lack of acceptance by society of the victim. There's so many things to it. Okay, and this poor girl, whatever this child, whatever, when it happened to her then, she's a woman now, she has to move on in life also. So probably she said, yeah, there was no penetration, the hymen is intact. And many times the hymen is intact even after penetration. And we don't want to go into this, on a public forum, but I'm just telling you that this is very, very insensitive, and we need judges who are more sensitive. I understand that he has to go by the law, but then like I said, we have to look at the woman and the psychological distress, her physiology, and what happens to her. Even if a man glares at a woman in a public space or anywhere else, a woman is threatened. But she's threatened. So when you say sexual abuse, a person who's gagged, whose clothes are removed, and then whatever happens.
Gagged, bound. There's a lot more surrounding it. It's not just a simple case of what happened, A or B. There's a lot more surrounding this. So in that sense, certainly the fact that force was used, the person was confined and constrained, all of these are certainly very important factors as far as this case is concerned. And there is a pattern. There are multiple courts which have had similar judgments, not as far as this specific crime is concerned, but which show an attitude of patriarchy. And that's where things certainly need to change. We'll have to leave it there. Pratibha Perala, Deepika Narayan Bhardwaj, Jay Dehadrai, Barkha Trayan, as well as Swapnil Kothari. Thanks so much for joining us this evening.